Mister, if you're ready to go forward in your motion, I'm ready to hear from you, okay?
I'd like to state for the record that I'm here on special appearance without waiving any rights, remedies, or defense and statutory procedural. I have a defendant's objection to jurisdiction and direction to move suit to Chancery Court. Defendant, by and through his attorney in fact, objects to the Circuit Court's jurisdiction and direct this court to transfer the suit to Chancery Court pursuant to TCA, which is to Tennessee Code annotated subsection 16-10-111 for the following. 1. All actions resulting from accidents or mistake. 2. All actions resulting from frauds, actual and constructive. 3. All actions resulting from trusts, express, constructive, and resulting. 4. All actions for an accounting and for surcharging and falsifying accounts. 5. All actions against minors in reference to their estates not cognizable at law. 6. All actions for the redemption of land or property. Adequate remedy cannot be obtained at law, and that there must be an accounting for profits, as I am alleging unjust enrichment done by the courts. And we want to see, we want a statement of cash flow, the inflows and outflows of cash, and where the money is going from the bonds, the municipal bonds, because I did put into the record the paper with the Committee on Uniform Securities Identification Procedure, which state that this case has been securitized. And we cannot move forward without a proper accounting, because equity delights to do complete justice and not by halves. And with that being said, I'd like to read also this into the record, that the protection, state and or the defendant's interest in case number 2023-CR-124 and case number 2023-TR-716 is equitable in nature. Defendant maintains that an accounting is a necessary element of the relief sought. Equity will undo what fraud has done. Fraud in the sight of the court of equity vitiates every contract or transaction into which it enters at the election of the injured party. And the court will not only undo what fraud has done, but will treat acts as done which fraud prevented from being done. A treatise on suits in chancery, second edition by Henry R. Gibson, 1907. And equity looks to the intent rather than to the form. Equity heeds not forms, but strives to reach the substance of things and to ascertain, uphold, and enforce rights and duties which spring from the real relations and the actual transaction of the parties. A treatise on suits in chancery, Henry Gibson, second edition. Equity regards the beneficiary as the real owner. In the court of law, in case of an express trust, the beneficiary is not recognized and has no rights the trustee is bound to respect. But in equity, where the intent of the grantor and not the form of the grant prevails, the beneficiary is regarded as a real owner, and the trustee is considered as a mere manager of the trust property for the benefit of the beneficiary, and liable to the beneficiary for any and every breach of trust. A treatise on suits in chancery by Henry Gibson, 1907. So I respectfully ask this court, since this is a court of law, to move it over to the courts of chancery, which is the equity courts, so we can go through the accounts and have a proper accounting for profits. Because in the court of law, I'm not going to get complete justice. They'll only do it by halves because they can't go into the accounting aspects of it. And so since we know that this case, by evidence on the record, has been securitized and monetized by the court, I'm here, I want to know about my interests, what part belongs to me, because I'm supposed to enjoin in the proceeds as well.
I'm looking at the docket here, and in Circuit Court case number 23-CR-124, it looks like you were charged with some traffic offenses.
Objection to...
Specifically driving while your license is revoked, failing to be able to provide proof of financial responsibility, this is the insurance law, and speeding. I don't know anything at all about the facts of your case, but I've read your motion. I know that you and I don't know each other. My understanding is you've come up here a few times from the state of Georgia, and that's a pretty long haul here. I've been at this for going on 14 years now, And I don't know who's advising you, but I try to treat everybody with respect. I say that about who's advising you because nothing that you've argued or filed in print here has any bearing, as far as I can tell, on the issue of whether you're guilty or innocent of these Tennessee code violations with which they've charged you. My job is to look out for your rights. That's obviously, you have the right to make them prove that you committed these alleged criminal offenses. The best way to do that is with a jury trial. I'm gonna save you the hassle of coming back and forth up here several times. I'm setting a schedule in your case. This case will be in part 2 with Judge Cameron where it initially began. I'm setting this matter for trial on September 27th, 2024.
September 27th.
Setting a pre-trial motions date of August the 30th, 2024. Both settings will be at 9 a.m. Eastern Standard Time here in the Circuit Court. I don't know whether and to what extent you're discussing this matter with the state of Tennessee at all.
Yes.
But if any kind of accord can be reached, if they decide to amend the charges down, or if you get a driver's license in the meantime and that changes things, I'll, obviously that you can get back in here sooner. But there's no basis in fact or law that I've heard or read today that would allow me to dismiss this case as it stands right now. It seems like a run-of-the-mill case.
Yes.
I've signed the order setting the matter for trial and establishing pre-trial motions, and that'll take care of this.
Can I say one thing, Judge? I'd like to say that I object to the, you said jury trial?
Yes.
I'd like to object to it because I just, for the record, adequate remedy cannot be obtained at law. And we need to discover the accounting, because if you all did not give me the accounting, that means that you all are covering up the fraud.
I understand what you're saying, and I'm not being smart. You may think I'm being smart, but I really try to be everybody's best friend in this courtroom.
Okay, well, can you give me the accounting if you're truly?
No, because there's no basis in law for that.
Well, that's what I'm saying. We have to go to equity, Judge.
No, we don't. No, we don't.
Or you're denying me equity, equitable relief?
Because this is not a court of equity, this is a court of law.
That's why you have to transfer. I just told you it's not adequate remedy cannot be obtained at law.
If Mr. doesn't want a jury trial, the state would agree to a bench trial.
As long as it's in chancery court in equity, because law cannot handle this type of case, especially when I gave you all the Committee on Uniform Securities Identification Procedures number, which states that it was marketable securities, municipal bonds, then coming from my estate. And someone has to be held accountable.
For the record, that the pretrial motion day is actually going to be May the 20th. That'll be in front of Judge Cameron as well, but the August date turned out to be setting for another trial. So the pretrial motion day will be May the 20th, and the trial will be September the 27th.
Gonna give me the paperwork, Judge, because they haven't been giving me any paperwork.
And you have every right in the world to request discovery from them, and then they have to comply with
Yes, sir. The other judge told them to send it, the discovery packet to me, and they failed to do it. So I want sanctions imposed on the prosecutor for failing to.
You can file a motion for sanctions and hear it on May the 20th.
Okay.
It is entirely within the discretion of the court whether to take up oral motions. I'm not going to get into the idea of sanctions today, but if they've got a good address for you,
yes,
send that to you, and if not, then it's your responsibility to provide them with one, so that it's a level playing field.
Okay.
You be back in court on May the 20th with any motions you got filed at that time.
May the 20th. Okay. So what do I do the application to get it changed over from law to equity? Because it looks like you all trying to deny me my equitable right to relief, which means that we may have to go to federal court for this.
And that's totally fine. I have read 100-page federal court orders dismissing all of this sovereign citizen.
Are you calling me a sovereign citizen, Judge?
I feel like that's what you're calling yourself.
Oh, you just biased. You biased. You just prejudiced the case, sir. And I'm not a sovereign citizen. I object to that.
Okay. Duly noted.
Because you all are embezzling from my estate, and you all are committing acts of unjust. Show me the accounting.
This is the fundamental disagreement that we're all going to have.
You're gonna hold me in contempt for asking for demanding my rights?
If you continue to interrupt him.
That's oppression.
I'm not going to hold you in contempt because honestly, that's a bigger headache for me than it is for you. I know.
Yes, because I hate for another judge to have to go to federal court, which we already have judges in federal court and prosecutors.
I haven't done anything wrong, so federal court is totally.
Okay.
I've been fair.
Okay. Well, have you had your property taken yet? Like you trying to take everybody else's property? No, sir.